All right, so there you have it, folks. You've got Margaret Rudin, the Black Widow, released from prison, served 20 years of her sentence, now on parole, just got to stay out of trouble. She's about 76 years old. And guess what? She wants a new trial. Let me bring in my think tank tonight. Joining us in New York City, trial attorney Brad Micklin. In studio, criminal defense attorney Joe Hibachi, criminal defense attorney Micklin Mercy, and criminal defense attorney, former prosecutor, former police officer Phil Holloway. Great to have everyone here. Brad Micklin in New York. She's gone to federal court, right? She's done with appeals in Nevada, so now she's gone to federal court looking for a new state trial. Really? Is the federal court going to step in and say, yeah, let's give a new trial to a woman who's already served her sentence?
It's a challenging question because the case has been up and back several times, which is why it's still going on. And I think there's something more at play here. I don't think her incentive is just because she wants to vote or be able to travel or even get off of probation. I think there's a financial incentive, like maybe it's going to make her book more marketable. But there's some other reason that she wants to persist and continue this trial so many decades later.
All right, I want to start with Brad Micklin, who is in New York City in our Court TV studios there across from the courthouse. Brad, where is the line? What's the difference between a fight and an assault? Because a lot of folks watching that video, some see a fight, some see an assault. Obviously, the jury saw an assault.
I think the beginning question is what instigated the fight? Was it two people? Did the gentleman in the blue shirt start by saying something or throwing something at the truck? But I think when you look at just the video, which may not have captured all of it, but when you look at the video, he jumps out of the truck with his arms up, and he's ready to fight. There's no question about it. He looked, for those of us that remember the old cartoon like Popeye, he walked out with his arms up. He was ready to go. I don't think there was any question he got out looking to assault the older gentleman.
All right, let me ask you, Brad Micklin in New York City tonight in our Court TV studios there. The other co-defendant is his friend/lawyer. Can he cut a deal and testify against his friend/civil client?
Yes. If the lawyer committed a crime, there's no privilege there. And even if the lawyer did break privilege, the penalty for the lawyer would be getting disbarred, which is likely to happen anyway. So in order for him to escape a murder conviction and going to prison for the rest of his life, he probably would forfeit his license anyway and say whatever it is that he knows. I mean, I think we're all waiting for one of them to flip on the other.
He's the $6 million man, Brad Micklin. Is that an advantage to be a really rich defendant with a mansion living in Connecticut?
Well, on one hand it does, because obviously he's got the resources for bail, he's got the resources for good defense. But on the other side, it taints the jury pool because a lot of people are going to be prone to think, you know, he's successful, he makes his own rules, he was standing to lose a lot in the divorce, so he had a lot of incentive. So it's going to count against him when it comes to an actual trial time.
Yeah, emotions. Brad Micklin, this is such a heartbreaking case. How do you defend someone who is responsible for the death of a 10-year-old innocent child?
It's challenging to represent somebody in a case like this. I mean, it's devastating whenever a child's life is taken, for whatever the reason is. And here, as my colleagues mentioned, we have a woman who chose to drink excessively, chose to get behind the wheel. I think the only way that you can possibly try to defend is either suggesting or trying to show that the alcohol did not necessarily cause the death, that it may have happened regardless of that, or maybe there's some kind of addiction or she was incapable of controlling herself. But I don't think either of those are going to work when you lose a life of a 10-year-old.
Yeah. Next comment comes from Tanya. I think that was a good deal for him. He could have gotten life if he was found guilty at trial. Also, the family does not have to go through the pain of sitting through a trial. Brad Micklin, do you see that as a real issue here? That prosecutors weigh not having to put a family through the pain and the uncertainty of a trial? Because this was a chaotic situation. Yes, there's a jailhouse informant. Yes, he allegedly made some statements afterwards, but still, maybe not the cleanest case.
And I think those are concerns that a prosecutor will have in all cases. And I didn't find it surprising that this case settled on the courthouse steps. Many cases do, of all types of litigation, because once you start a trial, and you see how your case is playing out, the balance of power changes. So it's not unusual. I think the concurrent sentencing is what motivated it. So I wasn't surprised by the plea. I was surprised that it was a second-degree murder case in the first place. And giving a concurrent sentence, anybody should have taken that, given the facts of this case.
All right, final comment from Michelle. I don't think 30 years is enough, especially for the life that was lost and others who survived may be suffering from the physical and emotional effects from the shooting. I just hope 30 years is enough time and he'll get therapy while in prison. I'm praying that in the future, Florida won't be releasing a very deranged 50-year-old man into society. Brad, let me ask you this. The other shooting victims, the survivors who got shot but didn't die, did they get any justice today with the shooter getting a concurrent sentence for shooting 6 people, 1 sentence?
Justice is a hard word to use, especially in a case like this. It depends who you're asking for the definition. What they did get was they're spared the time of going through the trial. They're spared their families going through the trial. They're spared the risk that he be exonerated or found not guilty or plead because of insanity. So as much as it's a hard pill to swallow, I think the victims did get a lot out of a plea, a lot of closure, and a lot of certainty. It may not be enough to undo the damage, but they certainly got something from it.
But we got special permission. That's Gigi Hadid, super duper model, Brad Micklin. She came into court, said, yeah, I've spoken and met with Harvey Weinstein. I know Selma Hayek. I know Charlize. I know all these people. Yet she told the judge and everyone else that she could still be fair and impartial. No way. She had an easy exit to get off of jury duty. Isn't she a great citizen?
Yes.
Yeah, I was shocked, actually, that she would take that kind of a position. It's not just whether or not she has any preconceived ideas about Weinstein or the other victims that she may have contact, but she also needs to be able to say that that won't change when she hears the testimony or finds out who the other victim that hasn't been identified is. The chance of her being tainted is so great that she should have walked out of there at the first opportunity she had.
All right, Chanley Painter at the courthouse. Big day tomorrow, and Harvey Weinstein, of course, will keep you up to date with that. Big thank you to our think tank tonight. Brad Micklin, Joe Hibachi, Eklund Mercy, and Phil Holloway. Thank you so much.